Hello, my name is Ali Khan and I'm a student of Jewish Doctor at Griffith University Nathan campus. My student ID is 5323753 and I'm here to give my presentation on global law. My assessment has two questions. The first question is further consisted of two parts. The first part is what is meant by the sources of international law. Sources of international law are basically the instruments of identifying legal rules as well as the methods adopted to create those legal rules. Academics have coined two different terms for the sources of law. The term material source is used to identify a legal rule, whereas the term formal source is used to identify the process adopted through which a legal rule transforms itself into a law. But in the realm of international law, there is no clear difference between material source and formal source. Sources of international law does not mean the physical electronic document that contain the law, but the ways in which the rules of international law emerge. The next part of the question is why, according to Mitchell and Beard, finding sources in international law a more complicated process when compared to the domestic legal system. In the domestic legal systems, the process of finding out a law on the specific issue is simple because the law is codified in the statutes or the previous decisions of the courts can also be used to find out the law in common law countries like Australia and the United Kingdom. However, in the international legal system, there is no universal legislature or judiciary to create the laws and to interpret those laws that bind all the states. There are international organizations and tribunals, but there is no system of hierarchy. Therefore, discovering the sources of international law and the methods of its creation become difficult than finding the sources in domestic legal system. The second question of the assessment has three parts. The first part is what are the sources of public international law? The classic sources of international law have been laid down in Article 38(1) of the Statutes of International Court of Justice. It states that the court whose function is to decide in accordance with international law such disputes as are submitted to it shall apply a international conventions, whether general or particular, establishing rules expressly recognized by the contesting states. Here the treaties are being referred as a source of law. B. International customs as evidence of general practice accepted as law. Here customs are being referred as source of law. C. The general principles of law recognized by the civilized nations. Here general principles are being accepted as a source of law. And lastly, D. Subject to the provisions of Article 59, judicial decisions and teachings of the most highly qualified publicists of the various nations as subsidiary means of determination of rules of law. Here judicial decisions and teachings of the legal scholars, highly qualified legal scholars, are being referred to as a subsidiary means of source of law in the international arena. Let's have a little discussion about these sources of law. As far as the treaties are concerned, treaties are official agreements between two or more countries whereby parties expressly give their consent to be bound by the rights and obligations enshrined in those agreements. Treaties, in contrast to the other sources of law, need the consent of the parties to have a source of law. Treaties, therefore, serve as the only way through which the states consciously develop international law. It is pertinent to mention here that not all the written agreements are treaties, and treaties become a source of law only when parties intend to be bound by its terms. As far as the customs are concerned, the definition of international custom in ICJ statutes, there are two elements that must be proven to demonstrate a custom as binding source of law. One, custom is a general practice among states, and two, the custom is accepted as law by those states. This requirement is known as opinion juris sive necessitatis or opinio juris. As far as the general principles of law are concerned, Article 38(1) is incorporating principles of law that are fundamental to the idea of any legal system as a source of law for international law. Judicial decisions can be highly influential in the development of the international law, but there is no doctrinal precedent in the international law. As far as the theory is concerned, judicial decisions do not create law as such. Teaching of the highly qualified publicists are also being considered under the Article 38 of the ICJ as a subsidiary source of law. The text of the Article 38(1) makes it clear that the sources of international law referred in paras A to C are formal sources of law, which means that they are used to identify the process for the creation of law. But the sources referred in para D are subsidiary means for determination of the content of international law. They are material sources of law as they are used to determine the alleged rules of international law. There are two additional modern sources of international law that have developed in addition to the sources laid down in Article 38 of the ICJ. The first is the creation of rules by international organizations that bind their member states. Second is the development of international legal norms and instruments that are non-binding but still have significant impact on the actions of state and non-state actors, and they are known as, or this source is called as soft law. The next part is, are the sources of public international law also source of private international law? In general, the sources of public and private international law include constitution, international treaties, legislation of states, judicial decisions, and scholarly writings. Among primary sources of public international law, only treaties serve as the source of public international law as well. Judicial decisions and writings of the scholars are a subsidiary source in public international law, and they also serve as a source of private international law. So, as far as the conventions, judicial decisions, and scholarly writings is concerned, there is an overlap between the source of public international law and private international law. As far as differences of these two sources are concerned, legislation has no role to play when it comes to the public international law, and customs has no role to play when it comes to the private international law. Our last part of the question 2 is, what happens when there is a conflict between different sources of public international law? When there is a conflict of different sources of international law, there are two general principles that can help us to determine that which source will have a priority in its application. The first of these is the principle of lex posterior derogate lege priori, which means that the rule that is later in time should prevail. The second of these is lex specialis derogate lege generali, which means that a more specific rule should prevail over a more general rule. There is also a concept of just cogents, which are the preemptive norm of general international law from which no derogation is permitted, and which can only be modified by a subsequent norm of general international law having the same character, as enshrined in the Article 54 of Vienna Convention on the Law of Treaties. Examples of these sort of norms include the prohibition on slavery and genocide. Any treaty or custom which attempts to effect a derogation from preemptive norm is necessarily invalid. As the treaties are increasing in their number, there are chances that there will be two or more treaties on the same subject matters, and there will be a conflict. Article 30 of the Vienna Convention on the Law of Treaties provides rules for the determination that which treaty prevails in the event of a conflict. Under paragraph 2, if a treaty states that it is subject to or not to be considered incompatible with another treaty, then the other treaty will prevail. Paragraph 3 states that if all the parties to the earlier treaty are also party to the later treaty, then the earlier treaty applies only to the extent that it is not incompatible with later treaty. Paragraph 4 deals with the situation where not all the parties to the later treaty have joined the later treaty. In this circumstance, if both of the parties involved with issue or dispute are party to the later treaty, then that treaty prevails for the purposes of the issue or dispute. That is it for my presentation today. Thank you very much.